Session, the Honorable Sean Quinn presiding.
Morning, everyone. Have a seat. I don't know if I like this. Oh, well. Too far away. Good morning. The case before us now is file number WC 236539, entitled Dilley versus Carver County. In addition to myself, the panel today is Judge Sundquist over here, Judge Christensen over there. I'll remind you both of the rules, although I'm sure you both know. You each have 15 minutes for your respective arguments. The burden is on you to keep track of your time. It's on the podium there. When your time expires, if we have additional questions, we will continue to allow you additional time to answer them. If not, your time is up. Appellant counsel, you can reserve as much or as little of those 15 minutes for rebuttal. You don't have to tell us, just keep track of your time. If there is additional time, the marshal will put that remaining time on your clock before you begin. We are live streaming and recording this. So acoustics in here are not the best, so outside voices. And with that, Ms. Storms, you may begin.
May it please the court, members of the court, and Attorney Boyce. My name is Katie Storms, and I'm here today on behalf of Carver County and the Minnesota Counties Intergovernmental Trust. We are asking this court today to reverse the October 16, 2023 findings and order of compensation Judge Alyssa Murillo in its entirety, and instead find that the employee was not entitled to wage loss benefits for the claimed periods of time, as the decisions of Judge Murillo were contrary to statutory and case law, as well as the substantial evidence of record. The most important takeaway for this court today is to recognize that the findings and order demands reversal because of its statutory nonconformity. As it reads currently, the employer and insurer have been compelled to pay 182.8 weeks of retraining, which is patently prohibited by a statute that leaves no room for interpretation. And because these benefits have already been paid, it removes the only remedy available to the employer and insurer to recover those benefits as permitted under Minnesota Statute 176179.
Ms. Storms, I'm going to interrupt you just for a second here.
Yep.
Well, longer than a second, probably.
Okay.
All right. So we know that you paid, well, the 182 weeks was what was ordered here. But isn't it true that the employee did claim that additional 25% under 176.102?
Yeah, I'm glad that you bring that up.
Didn't they claim that? And wouldn't that be sufficient to, if the judge had decided that, to allow for the 182 weeks?
Yeah, that's a good point. So it was never brought as a factual determination or issue for determination at the time of formal hearing. It was never brought up as an issue or cross-appealed by the employee. So we would posit for this court today that it's not properly before the WCCA for consideration. With that said, however, the way that Minnesota Statute 176102 subdivision 11A reads, the 25% is intended to be in addition or on top of the employee's compensation rate, not lengthen the number of weeks of benefit entitlement. Furthermore, there needs to be a specific showing of amounts, purposes, and dates of expenditures that flow from the retraining plan itself.
Ms. Storms, can I ask you, what authority are you using when
Sure.
indicate that the
This is the case FETTIG, FETTIG, versus ABB Combustion Engineering. This is a 1994 WCCA case. Specifically, this case awarded additional compensation to the employee for clothing expenses because the employee was required to dress professionally as part of the retraining plan. And he asked this court to award a clothing allowance, actually, because he did not have clothing sufficient to show up day to day back when things actually were in person and not all, screen time. But the court awarded clothing expenses, and that was considered something not contemplated by the retraining plan.
What about the duration, though? Is there any case law that you can cite that restricts that 156 weeks plus a 25%, the duration?
176-102 subdivision A indicates retraining is limited to 156 weeks hard stop. The 25% indicates that the employee who has been approved for retaining may petition the commissioner for compensation payable, otherwise payable. There's nothing in the statute that or case law that indicates it lengthens the number of weeks payable. It's compensation on top of the weekly retraining rate. And again, it's not intended for unexpected circumstances separate from the retraining plan itself. It has to flow from the retraining plan.
So what should a person do, though, who is medically unable to continue, not getting TTD because he obviously wasn't working at the time he was retraining, but if a person is in the position that he is in such a medically poor state that he cannot continue his retraining and it's due to the work injury, what's the remedy for that employee?
That, I believe, is for the legislature to consider right now, because there is no remedy in statute. Here, in Mr. Dilley's case, he did receive wage loss benefits for that period of time. The employer and insurer actually paid the retraining benefits. He received the 25.8 weeks while he was off recovering from the surgery. And then once he hit the 156-week cap, a NOID was filed, and it was later determined that those benefits were paid under a mistake of fact, and they should have been, suspended during that period of time while he was off work and recovering from surgery, and only reinstated once he returned to the retraining plan.
And let me ask a question on that, because in reviewing the file, I don't see any rehabilitation requests. Couldn't, exactly to your point, there was no rehabilitation request filed suspending the rehabilitation and retraining plan during this period, 25.8 weeks that he was off. Couldn't you have done that, and we may not be here today because that had been done, or not?
To file a request to suspend
during the period of time
plan.
he was off for.
We could have, I guess, done that, but we may have just been here on a horse of different color. Classifying those benefits is why we're here today, whether they should be classified as temporary total or temporary retraining, or temporary total or retraining benefits. And we would argue that they shouldn't have been paid regardless, because the employee was not participating in the retraining plan at the time he went out on his medical leave of absence and was not employed at that time. So the Workers' Compensation Act indicates that neither benefits should be paid. That's our law. Turning back to my argument then, the findings in order is not supported by the substantial evidence of the record as well, where the employee's job search is considered. There was nothing provided in the record to support the compensation judge's conclusion in this regard. The
Well,
employee,
The employee testified
the,
and
em-
she found it credible. I mean, can't we just rely upon that?
I disagree with that, Judge. I think it's important to note for this court that the only period you need to consider yourself with is March 31, 2022 through June 16, 2022. And there's nothing in the record or evidence that indicates the employee was performing a job search for that period of time. And that's the only thing that matters. The employee testified, yeah, I looked online, but the law and case law requires more. The employee had a QRC available to him. He had a QRC and jobs placement services available, and he declined to utilize those. He indicated in the alternative that he was being picky.
But didn't he
about-
just have 1 week of job placement left? He had used up 25 of the 26
It
weeks.
was reserved, yeah, it was reserved by the QRC specifically for job searching after completion of the retraining program.
But the period was 1 week, if I follow the record correctly. Is that right?
Right, but that's just for placement services. We've all practiced to know that a QRC does additional work in aiding an employee to return to work as allowed under 176-102. But absent some evidence in the record or objective documentation that the employee completed or participated in a reasonable and diligent job search and complied with the R3 that was in effect at that time, there is no evidence in the record that can sustain a finding that he completed a reasonable and diligent job search for the period of time for which benefits are in question. The QRC did not even file an R3 until January 11, 2023. Well, after the employee returned to work with the employer for whom he was working 4 years prior, and before he began working or before he began the retraining program. I also want to address the issues of, actually, before I get there, I do think it is important for this court to understand the timeline here because I think this case has been litigated quite a bit and there are a lot of dates that are being thrown around at you today. So we have the injury, which happened on September 27, 2015. The employee's first consultation with the QRC was performed on July 13, 2016. He was served and filed with notice of MMI on November 17, 2016, which was incorporated into Judge Murillo's record based upon a prior findings and order. On September 13, 2018, the retraining plan was submitted and approved to the Department of Labor and Industry. And on October 1, 2018, the employee began classes at Rasmussen. He started a medical leave of absence on July 10, 2019, and had his lumbar surgery on August 19, 2020. Or 2019, excuse me. He returned to school on January 5, 2020. We filed our first NOID on October 15, 2021, and our order on discontinuance was November 15, 2021. He graduated from Rasmussen on March 19, 2022, and the QRC attempted to restart job search on March 31, 2022. The employee filed his claim petition on June 21, 2022, and the employee returned to work at Waste Management on August 8, 2022. On January 11, 2023, the QRC filed her R8. I am going to save the rest of my time for rebuttal, but we do believe that the case law and statutory ruling is clear here today. We believe that Judge Murillo's order is contrary to case law, and there is substantial evidence in the record to overturn her finding that the employee completed a reasonable and diligent job search, and we're asking that this court today reverse her order in its entirety. Thank you.
Ms. Boyce.
May it please the court, counsel. My name is Mary Beth Boyce, and I'm here on behalf of the respondent, the employee, Brian Dilley. I want to start with the additional 25% issue because I think that's an important one here. It's not an issue for if it's appealed, it's an adequacy of the findings issue. And it's our position that this was specifically argued, articulated. This was on the claim petition was specifically for an additional 25%. And that the judge had a reasonable, without specifically citing the statute in her findings in order, that was what she had found that those additional weeks were for. There isn't, oh, sorry. Go ahead.
Well, go ahead. Go ahead.
There isn't case law specifically saying that the additional 25% is for those additional weeks. But if there isn't, what else is it for? We have I call it the grooming case in my head, but the free tag case for those additional benefits. And I know historically that it was just it was increasing the temp total rate before the statute then changed. But this additional 25% allows employees who have a work-related surgery in the middle of the retraining plan not get off base.
Doesn't, and you kind of addressed this already, but Judge Murillo did not make a finding that there were, and I'm going to use the exact language of the statute. I wrote it down. Due to unusual or unique circumstances of the employee's retraining plan. So she didn't make a finding that there were unusual circumstances or unique circumstances, and she didn't make a finding that those were of the plan. Don't we need that?
No, Your Honor. If we look at Ewell versus Metal Sales and Manufacturing, a case from February last year, because the hearing transcript, if you look back at the record, that they were specifically argued and articulated, it's clear that was what she was, I believe the statute says that they don't, in their rationale, they don't have to specifically say why that they're finding that.
But they have to make a finding. That's the thing that is troubling, which is, her memorandum, she doesn't have to explain why. It'd be nice, but she doesn't have to. But she seemingly has to make a finding that there are unusual or unique circumstances and that they're related to the plan. And I could see the argument that, hey, the surgery definitely fits all of that. And I could see an argument that, well, maybe it doesn't, but we don't have that finding.
We don't. We have the finding for the dates of the temp total. We also, I think in the worst case scenario, for at least for my client, would be that we would ask it to be remanded for that particular finding, since we asked on the record explicitly for this was the claim petition for those dates. We were asking that that she find that period of time to be the retraining and then the additional period of time as well. So I don't think it needs to be remanded to make that particular finding, but that would be, I guess, it wouldn't be a full reversal as a matter of law, but if the judge had to make that additional finding, that would be the recourse in our position for it. But we believe that the records is sufficient, that there's no other reasonable interpretation if that was an unusual circumstance. I want to also address the issue of the prior 239 conference. And it is, and like Ms. Storm said, it's a long history. There's lots of periods of time. So he has the surgery. He's off essentially for a semester, and the plan's extended by a semester. they noided him, but then reinstated, and then noided him again once he reached the 156 weeks. And then we had another 239 conference. It's our position that the Newen case shows explicitly that the memoranda is not a finding that's an appealable order from a 239 conference. So that res judicata and collateral estoppel do apply in workers' compensation cases, but they would apply to the issue of that time period. And they would not apply to an argument or something to substantiate that court order. And the Newen case addresses a lot of the issues with adopting a 239 conference opinion as to be used in later collateral estoppel or collateral. I can't even think right now. Collateral estoppel or res judicata issues.
I have a question.
Yes.
Because I've looked and maybe you can help me out here. In terms of the benefits at issue, the 25.8 weeks, I'm looking at some documentation. Should we interpret that as retraining benefits or are those temporary total disability benefits?
We would argue that those are retraining benefits. At issue, however, that issue is not in front of this court today, that they're arguing that it's a collateral estoppel or res judicata issue, not that the judge found incorrectly that they were retraining or temp total disability benefits. We believe that those are retraining benefits.
Then also it appears as though following Judge Grove's decision that there was, 179 was used to recoup some of the overpayment. And in looking at Judge Murillo's order, which is before us now, she found there was no mistake in payment of those benefits, which I assume is there. But also that statute 1.179 also requires a good faith requirement. I don't see that in the record. Do you see something?
Pardon
On
me?
179, there's on the overpayment, it supposed to have to be a mistake of payment, and also that your client received those benefits in good faith. Now I see where Judge Grove seems to say, well, it may have been paid by mistake of fact. Judge Murillo says no mistake of fact, but regardless, neither one of them found there was any type of good faith receipt by your client, which at least the way I look at it, you have to have that within the statute to take the overpayment. Do you agree or disagree?
I would agree. I think that the overpayment issue became a bigger issue because they didn't file a NOID to take the overpayment, and they should have filed the NOID if they were going to take that overpayment, and then that issue would have been addressed. But instead, my client received those benefits, and then they started reducing his ongoing benefits, but without filing anything, we would have had to have filed a claim petition to get that 20% back, which is essentially then what we did. And then moving to the reasonable jobs, the TTD post retraining, that 90 days post retraining, that the appellant's position would be a deviation from case law. The judge can rely on the employee's testimony that he performed a reasonable job search. He found a job not so long after. He's been found credible repeatedly. He was incentivized to work as he was not receiving benefits at that time, and that they failed to even initiate payments following the end of the retraining plan as well as required by statute. And that the assessment of the adequacy of a job search is the responsibility of the compensation judge, and she found that it was adequate. And then we would also argue I guess moving back to the collateral estoppel res judicata issue, that they waived the right to bring that as an issue as a part of an appeal, that alluding to it or knowing, I think without a doubt that the parties knew it was an issue, but if in order to make it an issue, they had to make it an issue on the record and ask the judge to do it. Otherwise, we're asking the judge to issue spot and for the judge to go through and decide and bring a statute and decide whether or not it's fine. That would be the same as asking the judge to look for a statute of limitations defense. That's not the judge's job. That's the party's job to bring it to the court's attention. And then the case law, it varies. There's a couple of cases that go different ways as far as what is sufficient to raise the notice issue, so that's that it's not unfair for the parties to address it. In Anwiller versus Luma Egg Ranch, the parties could not expand the issues to include statute of limitations and notice because it was not articulated. It was addressed in one of the parties' written closing arguments, and that was not sufficient. So it's a fact-specific analysis for the court to decide was there a reasonable period for the parties to then respond to it, and we would argue no. But again, we would argue that does not apply to memorandum within a 239 order, and that the case law is pretty specific and on point to that. And then I guess going back to the 25% over the 156-week cap, because I think this is probably the most important part. Again, this was raised multiple times in the record. We're not appealing his entitlement to benefits for a specific period of time. This is, again, the adequacy or sufficiency of the findings argument. And then the WCCA looks to whether there's substantial evidence to support the conclusion reached by the compensation judge. And we would argue that she doesn't have to find a specific finding and cite the actual statute, that she concluded that he was entitled to this benefit.
And again, just to pick up where Judge Quinn had asked you, because people say every once in a while we like to come to our own fact conclusion. Wouldn't she have necessarily had to make a fact finding that the circumstances, the surgery was an unusual or unique circumstance, at least citing to the statute, as opposed to us inferring, as you're suggesting?
I think that her finding that that he had the surgery, that it was unexpected, is sufficient to support that conclusion in her factual findings. And that there's no other way to interpret her findings, even if we look at it on its face, that there's no other way to say that his surgery was unexpected or unusual in a deviation. And that this 25% in the statute is specifically for circumstances like this, to allow him not to have to leave the retraining plan, to extend the retraining plan, to get through this, and to allow him to have these additional benefits while he's in school. And that the specific showing of amounts, dates, and expenditures is very clear, that we're looking for those specific number of weeks. And this flows from the plan as well. And again, there's no case law specifically on duration that 25% doesn't include an extension into that. And then moving to the collateral estoppel res judicata, even if this court were to find that her Judge Grove's statement within a 239 conference is sufficient, 239 rationale is sufficient to be an appealable order. Res judicata requires a judgment on the merits. The prior claim involves the same cause of action, and the issues have to be identical and full and fair opportunity to be heard on the merits. It's not the same cause of action. It's a different. The judge already concluded that he was entitled to those benefits. The issues are not identical because we were not asking for that additional 25% at that conference. The cause of action did not exist at that time. And then res judicata and workers' compensation cases are very narrowly applied. If you look at Alexander versus Kenneth Lalonde Enters, it's a 1980 case. And we want these to be narrowly applied because in a 239 conference, they're short conferences to expedite the process to determine whether the employee is going to have benefits or not for a certain period of time, not a full evidentiary hearing. And then collateral estoppel is the issue preclusion branch of res judicata, so slightly different, but the issues must be identical to the one in a prior adjudication. There was a full judgment on the merits, and those do not apply in this case. So we ask that you affirm Judge Murillo's decision. Thank you.
Thank you.
Thank you.
Ms. Storms, you have some time for rebuttal.
I do want to expand further on the idea that the additional 25% compensation can extend rather than increase the compensation. I would posit that extending the number of weeks allowed under a retraining program is a unique function of the legislature, and had the legislature intended the statute to lengthen the number of weeks of benefit entitlement, it would have done so. Again, there is no case law to support what the employee is asking this court to do today. Furthermore, what case law does tell us is that the additional 25% must flow from unusual or unique circumstances. This is what the statute contemplates. And it must come from the retraining plan itself, not from the circumstances surrounding the retraining plan. And these circumstances must demonstrate a financial burden on the employee, which was not demonstrated at the time of hearing. I am quoting specifically from Brewick versus Bricks and Sons. This was cited in my brief, but that's 45 WCD 58. The employee does have the burden of proving this, and these include evidence of specifically attributable plans flowing from the particular aspect of the plans itself. Thank you.
Any more questions? Thank you. All right, that concludes the oral argument. Thank you both. It was very enlightening, and the record is closed, and we will have a decision within 90 days. Thanks.
Thank you.
All rise. Court is now adjourned.
Recording stopped.